ladies and gentlemen of the jury.
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 We had everything you've seen on television and in the movies.
I live inside my own world of make-believe. Kids screaming in the...
Robert Buckland, the Lord Chancellor, announced that jury trials may be removed for either way offences in the UK because of a result of the coronavirus pandemic.
It is with the deepest sense of pride that I stand before you as Lord Chancellor.
In the UK, we have a Crown Court and a Magistrates Court, and then we have many other courts of appeal. The Crown Court tries the more serious offences, and the Magistrates Court tries the lower offences, but any of the offences that fall in the middle, these can be either way offences. Either way means that the defendant gets to choose whether they would prefer to be in the Crown Court or the Magistrates Court. So in the Crown Court, we get to sit in front of a jury. What's a jury? Well,
your duty to serve on the jury goes with your right to trial by jury.
Since the 12th century, when the Magna Carta was published, the defendants had the right to sit in front of 12 randomly appointed peers to decide their fate. These members of the jury are between 18 and 75 years old, and they have to be on the electoral roll in the UK, so they have to be eligible to vote. When you sit in a jury trial, the result has to be completely unanimous, so everyone has to decide whether you are guilty or not guilty. However, in some occasions, they can let this rule slide and it can be 10-2. But the judge tells the jury how to apply the law on the case, and the jury decides whether they think the defendant is guilty or not guilty. The magistrates sit in threes in the magistrates' court. You have a head magistrate and 2 other magistrates. These are volunteers. They do not have to have any legal work experience, but if they do, it doesn't matter. And they have a legal advisor who is knowledgeable on the law and advises them on how to apply the law to the case. So it sounds simple. The Crown Court, the Magistrates Court. And the Lord Chancellor is proposing we get rid of the Crown Court for either way offences, not the top offences like murder and things like that, because there is a backlog of 40,000 cases as a result of the coronavirus pandemic. Or is there? So Mr. Robert Buckland is proposing that we have 2 magistrates sitting with 1 circuit judge. Now, a circuit judge is an actual judge. They aren't a legal advisor, they are an actual judge. Why are we getting rid of the jury trials? The problem is that we need 200 venues to be able to cope with the backlog of cases. So why do we need more magistrates' courts? Oh, right. That's it. Since 2010, half the magistrates' courts have been sold. Bit of a shame really, because we might have needed them. So just to snip in here, Boris Johnson did mention the other day that he wanted to spend 142 million to spend on courts and build prisons as well with this money. But he only wants to refurbish 100 courts and build more prisons. Why don't we focus on putting the right people in prison rather than focusing on building prisons to put people in? Now, Robert Buckland's idea isn't a new concept. Like, this has been done before in Northern Ireland, and they were called Diplock courts because Lord Diplock recommended that in Northern Ireland, because of the troubles, they get rid of jury trials for terrorism offences at the time. This is because they felt some jurors were being intimidated and some jurors would find them not guilty even though the law pointed that they were guilty. However, Diplock courts don't really exist anymore. They can be used in some like offences, but they got rid of them because people felt that it weren't fair to do a trial without a jury. Now, you're probably thinking, Chloe, what's the problem with all this? Like, we're just trying to get rid of the troubles caused by the coronavirus pandemic. And I hear ya, but this is not the way. And it is very, very simple why. 4% of circuit judges, the judges who they are proposing sit in with 2 magistrates, are from a Black, Asian, minority ethnic background. So that doesn't exactly sound like we would all be represented equally. However, magistrates are a little more diverse. 12% of magistrates are Black, Asian, minority ethnic. So this is a bit more balanced. Magistrates typically tend to be pro-prosecution. What type of person do you think wants to sit in a court and play judge? Now, this is in the Holy Bible, which is behind me, the Secret Barrister. So you can read about magistrates there and the problems with them. However, there is some amazing magistrates out there who really do want to make a change to the criminal justice system. And I'm in no way, shape or form trying to disregard or put down the work that they put in. It is entirely voluntary role. So good on magistrates for doing that. However, a lot of magistrates can be pro-prosecution and do tend to decide a case with their heart sometimes rather than their head, unlike judges whose whole job it is to be impartial, and they have endured years of training and practice to do this, and even sometimes they get it wrong. That's why we have a court of appeal. 85% of magistrates are over the age of 50. 85%. So when you're coming up in front of judges who tend to be over 50 and 2 magistrates who are likely going to be over 50, if you're a younger person, you often can feel underrepresented. Now, does this sound very balanced to you? Let's remember the whole symbol of law is a set of scales. Again, Joanna puts this perfectly. When you are trying a case in front of a jury, there are 12 different judges with different ethnicities, sexualities, different experiences, different wealth, and they will see things from a different light. Whereas in a magistrate's court, there's just 3 judges who are going to be pretty much from the same background. Obviously not all of them are, but with the percentages that I've just given you, come on, they're probably going to be the same type of person. But the main problem with this proposed non-jury trials is why now? It's no secret that the criminal justice system has been on its knees for a long time. Funding for the Ministry of Justice has almost been quartered over the past decade. Legal aid is not available to the middle class anymore. Barristers who have thousands and thousands of pounds in student debt are working for less than minimum wage. Prisons have been privatised and are run by companies like G4S and Sodexo for a profit. Furthermore, before the COVID-19 situation, which obviously I'm not trying to take light away from, there was a backlog of 37,500 cases in the criminal courts in the UK. Now, there is a backlog of 40,000 cases. So why now is this being proposed? The fear is this is being proposed just to be swept under the rug and to get rid of the backlog and to blame the backlog on the COVID-19 situation. When in reality, the backlog was already there. The criminal justice system was already crumbling. This isn't a new issue. This has been an issue for a long time. If this was the NHS and 37,500 operations were due, what would the proposal be? To have a voluntary surgeon come in and to operate on people? You have to look at this as if you are going to be the person who could falsely be accused of a crime. I know we think
criminals are all the same,
but we have to get out of this mentality. People are falsely accused all the time and we need to give them a right to a fair trial. This is literally one of our human rights. So this is all just an idea for now, but I just wanted to give people a quick insight into what could happen, what would life be like if this proposed idea by the Lord Chancellor was allowed into Parliament. Now, I think it's unlikely because there has been a huge outcry from solicitors, from barristers. So if you like this video, please do like, comment and subscribe. Thanks for watching.